Right. Good morning, everyone. We're just going to give a little time for more people to trickle in from the Zoom waiting room, but welcome and looking forward to speaking with everyone soon here. All right. Well, I think we should kick off. We have a lot to get to, and appreciate everyone making the time this morning to log on. So, just a couple of housekeeping items before we jump in. First, we will have the Q&A active. So if you have questions as we work through the presentation materials here, please feel free to use that Q&A function, and we will do our best to either address those questions as they come through, or we can also allow some time at the end if needed. If you are seeking CLE credit, you should have received a form by email. And just a reminder that after the presentation, please complete that form and send it back, and we'll get you your CLE certificate as quickly as possible. And there will be two CLE codes hidden throughout this presentation. They will not be very hidden. It will be very apparent, but we'll share those as we work through the materials. And with that, I guess we should just jump in here because, as I said, we have a lot to get to. So, by way of introduction, I'm Glenn Sheik. I lead the immigration practice group here at Harder, Seacrest, and Emory, and I'm joined by my two wonderful colleagues, Rebecca Bentley and Liz Lindholm. And we are here today to talk about the prior year of developments under the Trump administration with regard to immigration law and to hopefully give you a sense of what's coming next. So, a lot of content, and we'll do our best to work through all of it here. So, just to start, we always like to share a picture of our wonderful team here so that you can be assured that it's not just three floating heads in a Zoom meeting, but in fact, we have a robust team here, nearly 20 people at HSE, who are all focused on, largely speaking, employment-based immigration matters. So, it's not just us. Every day of the week, all of these people are working extremely hard to help keep track of everything that's going on and support our clients accordingly. So for today, really, we can think of this as a look back and a look forward, right? We're going to start by going over the key developments in the past year since January 2025. And uh, there's a lot there. But what we're hoping to do is just paint a picture for you of the current immigration landscape. So, looking at specific changes that have occurred, but overall, we want you to be able to take a step back and say, okay, here's what it's like right now in the U.S. Immigration law, landscape. We'll then spend a little time pulling out our crystal balls and doing some predictions for what we might expect in the coming year. Some of that is clear because the government has told us what they plan to do. In other cases, it's just us kind of making predictions based on what we've seen. And we'll wrap up then with some action items. As an employer, what can you be doing? If you're here on a visa, what should you be doing to just make sure that you're prepared for the current environment and what might be coming next? And just at a very high level overview of what we've seen in the past year, and we'll go into much more detail on these items. But I think over this year, we've seen a few different buckets. If you wanted to sort of categorize all of the different changes and policy directives that we've seen, the first and the one that grabs the most headlines is the enforcement side. So here we're talking about, ICE presence and the government's focus on detaining and removing people who are here in the U.S. without authorization. This is what's making the headlines, and it absolutely has been a key focus of the Trump administration. So we'll spend some time talking about that. We've also seen the Immigration Service dismantle many humanitarian programs. So, in our immigration system, we have a number of programs that are designed to help people who might be having a tough time in their home country. Things like temporary protected status, humanitarian parole programs, different things that we've enacted over the years to provide some temporary relief. And the administration has really focused on these programs and essentially trying to dismantle them with some limited success over the past year. Another focus that we've seen, something that was present in the prior Trump administration, was a focus on travel restrictions and visa restrictions. So we now have some new travel bans that target particular countries and citizens of particular countries. So we'll talk about those in some more detail as well. When it comes to employment-based immigration and sort of where the three of us spend most of our time, honestly, the administration has not enacted tremendous changes over the past year that materially change the immigration landscape. There are a few. So we'll talk about the $100,000 fee for H-1B visas, which is, as, as it sounds like, it is a material change. Um, and overall, we have seen some more scrutiny on visa applications. But by and large, we are still getting cases approved, and we have not seen the sort of drastic changes with employment-based immigration that we're seeing in some of the other areas. So with all of that, I will turn it over to Liz, who's going to take it away, diving into the world of immigration enforcement.
Thanks so much, Glenn. So this, like Glenn mentioned, this is kind of the big thing that's on everyone's minds. It's in the news. It's affecting a lot of people, and it can definitely seem really scary. Something to think about here is we've seen a lot of increased willingness to use a lot of the tools that are in the immigration enforcement toolbox. But all of these tools have been in the law for a while, at the very least since really 2002, 2003, in the wake of 9/11. Um, but definitely a huge difference in the willingness and now also the budget to actually pull out every single one of these statutes and apply them as much as possible. The big thing I think with with the budget, especially the one big beautiful bill, added 170 billion with a B dollars to the ICE budget over 4 years. That was no small increase. It was a huge amount of money flooding the agency. And that really just means more officers, more facilities to detain people. And we're really seeing just a huge focus on, from top down, and an emphasis on just the, like, how many arrests did we have today seems to be a question that's being asked. How many people did we detain today? How many people did we deport or remove from the United States? Um, that's a big shift in where the goals of the government are usually. And to no surprise, we're seeing a huge amount of arrests. Um, and then kind of thinking about, okay, how are they arresting all these people? Where have they been? What's going on? They also added some policies or changed internal policies to remove protection from what were called sensitive areas like schools, hospitals, courthouses, or other government facilities. There was a policy for many years saying, hey, don't do immigration arrests at FEMA shelters or at public schools or at hospitals. We don't want to discourage people from going and getting these services. And that policy was rescinded and replaced with, I think it was a one sentence, use your common sense, directive to each individual agent. So definitely not prioritizing how immigration enforcement might impact a community and prioritizing just getting as many arrests as possible. Another way they've been trying to increase arrest numbers is, like we've seen, I think this is the biggest thing in the news, is this kind of dragnet style of descending on a particular city, a particular area, a particular community where they think there might be a lot of folks of who aren't U.S. citizens, and trying to scoop up as many people as possible to increase those arrest numbers. Um, yeah. And we're also seeing as they're doing this, if the goal is more arrests, you're going to come into the meeting the edges of the Constitution. In particular, expanding on internal, so when I say internal, I mean ICE or federal government interpretations of the limits of the Constitution, in particular the Fourth Amendment and the Fifth Amendment, and where, who, when, and where all these arrests can be made. A really big item that I think is really important is what we're calling, or what people are calling Kavanaugh stops, because of a concurrence in a shadow docket opinion, where essentially the court said it was permissible for ICE to stop people and engage in immigration enforcement activities solely on the basis of race, ethnicity, or the language that they might be speaking. So really kind of testing the limits of where all of where this federal authority to arrest, to detain, to deport can really stop and start. And courts, understandably, no one in the legal field expects the legal system to move quickly, but they have been slow in addressing these issues, and a really big limitation on district level courts to address these issues has been a limitation on their ability to issue nationwide injunctions. We've seen that in a few different areas where they can only the precedent now is to limit the scope of that temporary restraining orders or temporary injunctions while these cases work through the court system. And so, a great example is the tariffs. It's not immigration, but it's exactly what happened there, where they were not enjoined, so the tariffs were still in effect. And then a year later, the Supreme Court says that they weren't lawful, and now they have to figure out how to undo or redo a lot of the money that was taken. So it's kind of a move fast and see how far we can get kind of attitude I think we're seeing out of immigration enforcement. Another question you might be asking is where are we getting all of these people to be arrested? I had no idea so many folks were in the United States unlawfully or without work authorization. And I think on the next slide it kind of answers that question. Um, they're almost creating a self-fulfilling cycle in taking these humanitarian programs and either limiting them or ending them. They're creating populations of people who previously were authorized to be in the United States, to work, to pursue their lives, and then ending that. So kind of taking out the safety net, suddenly folks become eligible for arrest or detention. So the two really big ones that come up, especially for employers, is the TPS, that stands for Temporary Protected Status. Protected status meaning that they are protected from removal because something has gone wrong in their home country, either a natural disaster where it's not safe to return, a war, or really any kind of circumstance or combination of circumstances that would make it unethical to force someone to go back there, even though that might have been their plan originally. At the start of 2025, there were 17 different countries designated for temporary protected status. That means citizens of those 17 countries were eligible, usually in 18-month increments, to remain in the United States, to have work authorization that gets automatic extensions by regulation. And then starting very early in 2025, after the Trump administration took office, they started terminating these programs. Some of them at the time that they were expiring, but many of them just right in the middle of that authorized period. So we went from 17 down to 5 in just a year. And those 5 are set to expire at some point this year. So we don't have high hopes that they will expand these programs. And something really important to note is that of the 12 countries that have been terminated from temporary protected status, 8 of them have been extended by court order in 8 different cases, all with slightly different legal theories. and at varying stages of litigation. And so it's temporary good news that the employment authorization, the ability to remain in the States, is extended, but the uncertainty of when that could change or will change, and people's lives really hang in the balance of whether they can keep working, whether they can keep staying in the U.S., or whether they might become suddenly subject to arrest and detention and removal. Um, so that's a very hot topic in this area, and a area that's especially difficult, I think, for individuals and employers to try and navigate. And then also the humanitarian parole programs. These are programs where, similar to temporary protected status, except where TPS requires that someone's already in the United States at the time that that temporary protected status is designated. They're imagining someone is visiting Disney World, and then a war breaks out in their home country, and it would be terrible for them to have to go back in the middle of all of that. If they're in the US, they can stay while that problem sorts out and they don't have to be put in danger. Humanitarian parole programs are a little more expansive. They're saying something's going wrong in your home country, you are there, and we can parole you with a pathway to a more stable status in the United States. So there were 5 programs at the start of 2025. 2 of them have been terminated. There haven't been any court cases successfully undoing that, or pausing that. 1 program has been suspended, so it may be put back, it may not. But notably, the only 2 programs that remain are Uniting for Ukraine, and a military parole in place program. And that program has been specifically for military members and their family members to have establish a pathway to a more stable immigration status, kind of in exchange for their service in the U.S. Armed Forces. Um, so we're seeing a shrinking population of people who are protected, and then therefore a larger population of people who are now suddenly subject to that arrest and detention and removal that supports those increased numbers. So, as an employer, what are you supposed to do? You can't be glued to the Supreme Court or federal court system uh, cases day in and day out. First of all, I guess that's our job, so subscribe to the HSC's updates. But also, it's really difficult to navigate with e-verifying with I-9 compliance by itself. There's conflicting and confusing information. Sometimes the courts writing these opinions don't understand the program and what it is they are extending or not. Last minute court rulings, they go into effect right away. Sometimes it's a Friday evening, and sometimes you don't know if you can have your employee come to work on Monday. Um, Another thing that is happening is that even where people still have valid employment authorization or EADs, those cards, there has been a policy to remove automatic extensions when someone files for an extension in a timely manner. So that means that where it used to be, if you just requested the new card before the old one expired, you could keep working while the new card came in, that policy is going away. So you're going to have folks who, uh, are authorized to work, will be authorized to work, but there's going to be a gap in their work authorization, and it's going to make it really hard to maintain that I-9 compliance. And unfortunately, that means employers have to really beef up your I-9 compliance programs. The law is very clear. You can't have folks who are unauthorized to working in your establishment. And so really thinking a lot about, are you performing self audits? Are you, double checking? E-Verify produces reports sometimes when they've terminated a program for folks whose work authorization terminated before the expiration date. You definitely need to be vigilant about re-verifications and making sure you've got all the right documents at the right time. Um, so really strongly consider investing and looking into that. Um, and surprise, your first CLE code, spring. Um, I'll try to stay mum about what the second CLE code is. But I think that's the end of what is probably more of the doomiest and gloomiest section, I hope. And I would love to pass it over to Rebecca, who will be able to speak more on travel bans and also the updated H-1B program.
Awesome. Thanks, Liz. So some additional significant updates that you've probably been seeing in the news are travel bans. So right now, there is currently a pause on the issuance of immigrant visas for nationals of 75 countries. Now, for context, an immigrant visa is essentially what you get when you're applying for a green card from outside of the United States. And you enter with the immigrant visa in your passport as a lawful permanent resident. And that is currently paused for individuals from 75 countries because the government has deemed those nationals of those countries to be high risk of becoming something called a public charge, which essentially means the government believes there's a high risk that person may become dependent on government public assistance or benefits. An additional significant travel ban is there's currently either a partial or full travel ban placed on nationals of 39 countries. Now, this was announced in two presidential proclamations, one back in June and one in December. And in these proclamations, essentially, President Trump is noting that these individuals are considered high risk for certain factors. For example, a threat to national security, or maybe there's a history of overstay. And for those reasons, those nationals are either subject to a partial, so for example, those coming in as a visitor, J1, or a student, or even a full travel ban. Now, because of these travel updates, and we are recommending ultimately that individuals avoid international travel, particularly those who are here in a temporary visa category. This is because these travel updates can come with limited to no notice. And we just don't want anyone to be in a situation where they're outside of the United States and they're put in a tough spot because of some sort of new travel update that came and they ultimately aren't able to come back because there was very limited or no notice given with that update. We can kind of move on. This is a snapshot essentially of all the countries that are subject to the immigrant visa, the pause in the immigrant visa processing. So you can kind of see what countries are being targeted a little bit more. So, for example, in Africa. And then on the next slide, we have an overview of the snapshot of the partial or full travel bans. Again, you can kind of see the countries that are being a little bit more targeted here are located in Africa and a little bit in Asia as well. And then additionally, in addition to these rapid travel updates, we're also seeing increased scrutiny on all visa applications and petitions. So in US immigration, there are visa categories that are often referred to as alphabet soup. So you're essentially applying under one of the visa categories under the INA, so the Immigration and Nationality Act, and you're requesting status in, for example, an H-1B or an F-1. Right now, under the Trump administration, there is heightened scrutiny being placed on all visa applications and petitions across the board. So something to keep in mind is there is going to be advanced vetting and screening of all visa applicants, and we can kind of touch on that on the next slide. And essentially, or Glenn, would you mind going to the next slide? So there is increased scrutiny being placed on all visa applicants. So in line with this increased scrutiny, we are seeing the Department of State announce that they're going to be taking a much closer look at everyone's online presence. So they're going to be participating in advanced vetting and screening of all visa applicants. So this is something to keep in mind particularly when you're applying for a visa, that an officer is going to be looking at your social media. They're going to be Googling you. They're going to see what comes up, and they're ultimately looking for language that they deem as un-American or anti-American, or maybe some sort of negative comment to the United States, or something that's a little bit more politically charged. And those are things to keep in mind because that's what the officers are ultimately going to be looking out for. Now, in addition to that, and this kind of touches on the recent travel bans, USCIS also announced that there's currently going to be an indefinite pause on the adjudication of all benefit applications. So this applies to benefit applications that are being submitted from nationals of those 39 countries that are currently subject to the full and partial travel bans that were announced under those presidential proclamations. Now, because of this, we should expect very extreme delays. This doesn't mean that individuals shouldn't submit their applications. And for just so you know, when I say benefit applications, it's kind of a vague definition that the government provided, but this does include requests to adjust status, and this does include applications for employment authorization documents. Now, if you are a national from one of those countries, or you're an employer who's employing someone that's a national from one of those countries, still get in those applications and still submit, but just know that you should expect some extreme delays. And right now there is no end date in sight, and it's kind of a little bit unclear of how this is actually being accepted and processed or even viewed by the government since this update has been announced. Now, in submitting visa petitions with the government, we are also seeing a lot more pushback. The officers are taking a much closer look at what is being submitted, what is the supporting documentation, and using their discretion to issue something called a request for evidence. So a request for evidence is where the government is saying, we want you to provide more information. We want you to provide more supporting documentation. So cases in the past that may have ultimately gone through and been approved without a request for evidence are now seeing that additional pushback. So that is something that we want to keep in mind. We want to make sure we're providing maybe a little bit more documentation than you would have in the past, taking a closer look at the details of the case, and be ready to get that pushback and be prepared to be able to address that if that does come up. Now, in line with that, because there is closer scrutiny being placed on these applications, a little bit more pushback, things are taking longer. And also because the government is doing that increased vetting and screening, additional security background checks and taking a look at people's social media and taking a closer look at someone's background and immigration history, that all takes time, and that will add to the application process. So we are seeing, longer delays in processing. Appointment wait times can be pushed out. For example, in India, we did see recently a bunch of visa appointments being rescheduled several months out, and that we believe is due to security background checks being placed, additional scrutiny being placed on social media. So that's something to keep in mind. And you just want to make sure that when you are going forward with these applications, we are still seeing approvals, we are still seeing things going through, but you just want to make sure that you're planning ahead and keeping in mind that it may take a little bit longer and it may take a little bit more time and effort to put it together because you may need to provide some more supporting documentation as well. All right, now the next category is the H-1B that I want to discuss. You've probably seen this all across the news, the $100,000 fee. This caused quite a bit of panic. So on September 19th, President Trump issued an executive order that essentially barred entry of all H-1B workers unless their petition was filed with a $100,000 fee. Now, as you can imagine, this was announced with limited to no notice, and it caused quite a bit of panic, especially people that were traveling that day or had imminent travel plans. About a day later, USCIS and Customs and Border Protection issued guidance that significantly walked back the H-1B travel restrictions. And so right now, just to clarify, the $100,000 fee still applies, but only in limited situations. So under the current guidance, the H-1B $100,000 fee applies for individuals who are filing an H-1B petition on or after September 21st on behalf of a foreign national who is outside of the United States. Now, in another scenario, if let's say someone's inside the United States and an employer files an H-1B petition on their behalf, but they're not eligible to extend or change their status. Now, when I say change, I mean, for example, maybe a student in F1 status wants to change their status from F1 to H1B. If they're not able to effectively extend or change their status from within the United States, then they would effectively have to go outside of the US to apply for that visa and enter an H-1B status. In that situation, the $100,000 fee would apply. Now, there is something called a national interest exception. This is not something that I would rely on. It's an incredibly high threshold. It's issued, but the government even said it would only be issued in very rare circumstances. And to date, we haven't actually seen this be approved from anyone. So it's an incredibly high bar. And so if you are subject to the $100,000 fee, know that you can try for the exception, but I wouldn't rely on that. So it's best to work with legal counsel to try to find a way to maybe avoid the $100,000 fee, maybe trying to find a way to change your status from within the United States. Now, another major update is to the H-1B CAP petitions. So for those who are subject to the H-1B lottery, CAP subject employers, the H-1B lottery happens once a year. It's about a 2-week window. And basically, because so many people want the H-1B visa, there's a lottery that happens. And the employer can register whoever they want to bring in an H-1B status or file an H-1B petition on their behalf within the lottery. And in the past, everyone got one entry who was registered. This year, that's changed. So under the new wage-weighted selection process, the government's now saying, okay, everyone will still get a chance. You can still be placed in lottery and still be considered, but the higher income that you're offered, so you're higher the wage that you're given within your occupation, the higher the chance that you'll be selected. So in general, there's about 4 wage levels that are assigned to each occupation. And generally for wage level 1, that's considered a more entry-level position, whereas a wage level 4 is for a more senior level position. So that wage level would be naturally higher. Now, if you're given and your offered income ultimately falls within wage level 1, then you're given one entry in the H-1B lottery. In the same vein, if your wage is offered income in the H-1B role is ultimately falls under wage level 4, then you could get 4 entries in the lottery. So this does weigh in the favor of individuals who are going to be paid more and give them a higher chance of being selected. But again, everyone can still be considered if they're registered. There is a higher chance given to those who would be paid more in their occupation. Now, just for reference, the H-1B lottery is open now. It opened yesterday at noon, and it runs through March 19th. So if this is something you're interested, I would definitely get on that right now. There is a little bit of front work that comes with it because you want to make sure that you can see how many entries you're eligible for, but there's still time. So keep that in mind and just make sure you're getting on that right away because there is a strict deadline of March 19th.
Thanks, Rebecca. And yeah, that's an excellent plug for the immigration group here. Any employees that might be on a temporary status like an F1, or Liz was talking about people on humanitarian, parole programs like TPS. Any employees in that circumstance, it's really, really helpful to look at them and consider if you are subject to the H-1B lottery, meaning you're not a college or a university or a hospital, for example. The H-1B lottery is very time sensitive, happens once a year, and we have a great team who's working hard on those as we speak. So I wanted to spend a little time here thinking about what's next, right? After this year, we can sort of reflect on what's happened and make some educated guesses about what we could see in the coming year. So some of these really are just a continuation of what we've seen so far. We learned about, the erosion of these humanitarian visa programs like TPS. There are some proposed rules coming down that would limit work authorization for people seeking asylum. And it could be that DACA, for example, gets some scrutiny in the next year. So we've just seen this trend of humanitarian visa programs ending, and I would expect that fully to continue over this next year. Uh, to Liz's point about enforcement actions, there doesn't seem to be any slowdown on this. Uh, we're seeing ICE securing new spaces to build detention facilities. We're seeing continued funding and continued arrest quotas. So I would fully expect that over the next year, we'll continue to see that sort of action. And it would be surprising, honestly, if it were to slow down. And to Rebecca's point about the travel bans, we're seeing the president use executive powers to make very swift decisions about groups of people to restrict from the U.S. in terms of entry, and also pausing benefit applications for people in the U.S. And we would expect that to continue as well. It's been a focus during this administration and the prior administration, or the prior Trump administration. And so we would expect that to continue here as well. But overall, the first bullet point here is, I think, the one that stands out to me, which is uncertainty, right? A lot of the developments that we've seen over the past year have been a complete surprise. We follow this stuff very closely. We spend a lot of time tracking what's going on. And, candidly, a $100,000 fee for H-1B visas was not on my 2025 bingo card. And it happened on a Friday evening and took effect on a Sunday morning, and really not much advance notice there. So I would expect that same type of uncertainty and unpredictable changes that we really can't sit here and predict. There's no crystal ball that would tell us what might be on the agenda, but I would expect that changes that do take effect will happen without much advance notice. Another thing we wanted to touch on here is government shutdowns. Now, by and large, the Immigration Service is fee funded, which means when the government shuts down, the Immigration Service normally continues to process applications. But there are certain visas and certain green card filings that rely on the Department of Labor for a pre-approval in some form or the other. And the Department of Labor is not fee funded and is impacted by government shutdowns. So when the government shuts down, what happens is immigration processing does slow down. So it's important that you track, or we track, possible government shutdowns and take action ahead of time so that our clients are not kind of caught unaware, and slowed down or impacted by such a government shutdown. Another thing I just wanted to mention here, and this is really comparing this Trump administration to the prior Trump administration, we are seeing fewer successful legal challenges. During the prior Trump administration, it was really like a rule or a policy would be announced, a lawsuit would be filed the next week, and it would go back and forth. It was like it's paused, it's back on, it's paused, it's back on, as courts would issue injunctions and sort of dial back the scope of different policies. This time around, the Trump administration is drafting its policies in ways that make them less susceptible to legal challenges. So, with the limited exception of the TPS litigation, and groups have been successful in pausing that TPS, those terminations of TPS programs to a certain extent, Um, in other areas, such as the travel bans and this $100,000 fee, to this point, legal challenges have not been effective at pausing or sort of rolling back the government's plans. So I would also expect in this next year that we would not see many successful legal challenges rolling back the government's authority here. So I mentioned this at the beginning, but the government has also given us some hints for this presentation because they put out ideas of what regulations and rules they hope to pass in the next year. So these are not just predictions. These are things that the government has said, look, we are actively planning this and are looking to make some changes in these areas. The first, this is a rule that was actually supposed to be published for review in January, and it was not. We're still waiting on it, but that's not uncommon. Is to tighten the standards for some subjective green card filings. So if someone is applying for U.S. permanent residence under a national interest waiver category or under a category that requires exceptional ability, or extraordinary ability in the context of an EB1 filing. These are, as the bullet point indicates here, subjective green cards, and the government is proposing to tighten the standards here and essentially make it harder to get these types of green cards. So if you have someone who's looking at this type of green card and you may be thinking about moving that forward, I would recommend doing that sooner rather than later so that we're able to process it under the current standards, which are more favorable than what's coming up. Within that H-1B proclamation that Rebecca was discussing, the government also directed the Department of Labor to investigate and report on the way that it calculates those wage levels. So for H-1B visas, certain other visa categories as well, and green cards, there can be what's called a prevailing wage requirement. And the idea here is that we want to make sure that we're paying H-1B workers and certain green card holders at least as much as other workers in the same occupation in the same area are being paid. So right now, there might be a prevailing wage at a certain level for, let's say, software developers working in Rochester. The Department of Labor is planning to sort of relook at the way those wages are calculated and very likely look at raising those wage requirements. This is something that was proposed during the end of the prior Trump administration. It did not move forward at that time, but the government has directed Department of Labor to look at this, and we would expect some action on this within the next year. Now, for private employers, this next one might not be critical, but I do know from the participant list that we have some friends from higher ed and healthcare on the line. So I wanted to touch on a proposed rule that will end what's called duration of status for F1 students and J1 exchange visitors. So this is something that would apply any international students enrolled at a college or university. If you're a J1 medical resident or a J1 clinical fellow, this rule basically would change the way that we admit these people to the US for a temporary program. As it stands, these individuals are admitted for what's called duration of status, which means they can stay here for as long as it takes to complete their program, be it a medical residency or a master's degree. And the government has a rule published that would propose to do away with this system and essentially admit these people for a given amount of time and force them to file extensions if they want to keep their status going. So that would be a major change to the way that students and exchange visitors are treated. We've also already seen the government roll back EAD, or Employment Authorization Document validity. And we used to have these auto extensions where if you filed ahead of time, you'd be protected and you could keep working while your application is pending, but those have gone away. We've also seen a proposed rule that would require an asylum applicant to be here with a pending asylum application for a full year before they can apply for work authorization, which would also be a major change from the current landscape. I guess this last one is not officially listed in the regulatory agenda, but I also do expect some changes to the perm recruiting process. So the perm recruiting process is a green card sponsorship pathway where we test the labor market. And the government established these recruiting requirements back in 2004, and they have not really been materially changed since then. The Trump administration has sort of focused on these recruiting processes, and there were notable Facebook or settlements with Facebook and Apple during the prior Trump administration based on their perm recruiting practices. So we might expect a more robust recruiting requirement under the perm process. So here too, just like the subjective green cards, if you're thinking about starting permanent residence, it's a good time to do so now rather than waiting until the standards become a little bit more difficult to work with. So, just thinking about what should foreign nationals be focused on, right? If you're here and you're a visa holder, or you're not a citizen, you're not a permanent resident, or if you're an employer and you have employees in this circumstance, our key recommendations. The first one, I can't say it loudly enough, is we are just recommending that you avoid international travel to the extent possible. And this goes back to what Rebecca was saying with the travel bans and the H-1B proclamation. These changes happen really quickly, and it's a lot easier to protect someone's status if they're here in the US rather than overseas trying to get back in. And we don't get a lot of heads up. So I always say when these proclamations hit, I become a little bit of a glorified travel agent trying to get people back to the US before the changes take effect. And that's really a difficult circumstance to be in. Uh, Another key planning consideration here is to carry evidence of your status at all times. This goes back to what Liz was talking about with enforcement actions, and we're seeing, increased ICE presence. This is a rule that's actually been on the book for a very long time, but has not been enforced in any meaningful way. But if you're here in the U.S. and you're not a U.S. citizen, basically, you need to be carrying evidence of your immigration status and be prepared to articulate that status to a government officer. Similarly, you're required to notify the Immigration Service of address changes within 10 days of changing your address. This is something that historically it's always been the law, but there hasn't really been a focus on it. And we've now seen under this administration specific guidance saying they want to focus on this, and it could be used as a pretext to create larger immigration issues for people. So if you change your address, please notify the Immigration Service within 10 days. And just generally, I won't go into too much detail on these because we talked about these previously, but social media, just keep in mind that this could be reviewed whether you're here in the US or particularly at a consulate applying for a new visa. It's something that's a big focus for this administration, and no real action item, but just to be mindful that it could be a point of focus. And it's not a great time to be terribly creative about your immigration status and pushing the bounds of what's permissible. It's a really good time to be compliant and conservative with your immigration status. So just be mindful of what's allowed and not allowed under your particular status. And if you have questions, that's what we're here for. Along the same lines, just some kind of planning ideas for employers here. The first point here, just plan for success, right? Liz sometimes says that if the IRS starts increasing scrutiny of tax filings, you wouldn't just not file your taxes, you would go out and get a really good attorney or accountant, right? So same thing here. Work with qualified immigration counsel. Make sure that you have a good plan for your sponsored employees and those working under different work authorization categories, and plan ahead, right? It's a really good time to enlist the help of counsel and make sure that everything is in order. Along these lines, prepare for government audits. We are seeing an increase in both I-9 audits, where ICE comes on site and wants to make sure that you have all evidence of work authorization for your current employees. If you have H-1B workers, there are separate compliance programs that are required. So just make sure this is in good shape. If you're not sure, again, that's what we're here for. And we help employers with self audits and training on these items very regularly. Another item that might not be immediately obvious is we would recommend starting permanent resident sponsorship for any employees, particularly those in precarious immigration circumstances. So if you have someone on TPS, and even if that TPS has been in place for years and it's never been an issue, those are really under fire right now. And the permanent resident sponsorship process can take 3, 4 years, more in some cases. So you don't want to wait until TPS gets terminated for a particular country or a parole program gets terminated for a particular country. The best thing you can do as an employer is start on permanent residence early so that you're putting yourself in the best position for what might be coming ahead. And then Liz talked about, the enforcement. We're getting a lot of questions these days from employers about, well, what do I do if ICE comes on site? And the best thing to do is to make sure that you're prepared for it so that you have identified, here's our first line contact, here's the training that these people will have, and that people know what to do if ICE comes on site and they know how to route those inquiries. And we're again happy to discuss that and provide training on that as well. And the news sources, right? You want to know what's going on, but I just want to point out that in a lot of cases, it's unpredictable, and the news might not get the message completely right. So for these 75 countries where the immigrant visas are paused, all of the news articles that came out the first day said that all visas were paused from these 75 countries, which is a lot different, right? It's unusual for an employer to have someone applying for an immigrant visa at a consulate abroad. So it ended up being much more limited, but there was a lot of panic that first day when people tried to understand exactly what this meant. So make sure that you're looking at reliable news sources. Our team puts out a great deal of content on these issues, and we're always happy to discuss if you're not exactly sure what's going on. And so with that, I will go to the final CLE code, which is forward. So with these two CLE codes, I suppose no one has an excuse to miss out on Sunday morning. And I guess we can have our own thoughts about whether we like the spring ahead or spring forward or not. But anyway, you're officially on notice. So with that, I do know there were a couple questions that have trickled in. So let me go to the Q&A here and see if we can address those.
Yeah, I think there were a few questions about if I can overgeneralize and maybe lump them together. One is, um, well, I guess specifically, do you have any insight for how refugees should prepare for re-interviews, and if they need legal representation? I don't have specific insight, but generally, if you ask a lawyer if someone needs a lawyer, I think our answer will almost always be yes. Um, for a little bit of context, people who have arrived in the US as refugees are being re-interviewed even after they've gone through the process abroad as part of a additional scrutiny there. Um, I can't see harm in having legal representation or at least a consultation with someone who practices in that area just to make sure all the T's are crossed and I's are dotted and everything's okay. Another question is whether an institution should be worried about folks coming from a few different countries and applying for visas. Worried, frankly, our job is to worry, right? I think we're worried about all of this. I think the things I worry most about are delays because there's things we just can't control. So getting people into visa applications as early as possible so that you can pivot if you have to, or build in extra time expecting delays, kind of a prepare for the worst, hope for the best I think would be our general recommendation there. And I
And
guess if you have specific questions, reach out to an attorney.
there's also a question about any updates or restrictions regarding the e-visa. And I will say we're still seeing approvals, still moving through e-visa applications. One thing to keep in mind is when you are applying for the e-visa abroad, we are noticing that it's taking longer to get the actual visa back in your passport. So for context, when, for example, in Canada, when you're applying for an E1 or E2 visa, you attend an appointment and an interview at a consulate in your home country and ultimately hand over your passport. Now, in the past, it may have just taken a few business days, but we are seeing, at least in a few consulates so far, it's taking weeks now to actually get the passport back with the e-visa inside. So you just want to make sure you're keeping that in mind, especially if you have international travel plans or business needs in the United States.
Yeah, and I also just wanted to touch, there was a question that I think Liz answered offline, but I think it's relevant to hear more broadly, which is regarding social media searches. And we talked about your social media profile being under more scrutiny. And the question was a good one and basically said, well, what if you have a private social media profile? And one thing that we're seeing is um, consulates are actually asking visa applicants to set their profiles to public and leaving them private. The consulate might take, this is their words, not mine, as evidence that the person is trying to conceal something. So if you're applying for a visa at a consulate, we do recommend that you set the profile to public. And again, there's no specific, I'm not here to say don't post things on social media or to treat that a certain way, but just to highlight that it's something they might consider, and so you should be aware of it and know what's there. Um, And I thought I saw another question, but oh, I guess it was answered. Um, so yeah, I think with that, I know this has been a lot of information, and I hope it's been really helpful. I just want to thank Liz and Rebecca, and the team here for setting it up, and for everyone making the time on this wonderful morning to talk about immigration law. It's what we love to do. So thanks for indulging us. If you have follow-up questions or things come up, after the fact, please just feel free to reach out. We're always happy to jump on a call or help out with specific issues as they arise. Take care and have a great day.